I was sitting on my back porch in Asheville, North Carolina, watching the sunset paint the Blue Ridge Mountains in shades of orange and purple when I noticed the survey crew. 3 men in high-visibility vests were walking along the edge of my property line with equipment, taking measurements and driving stakes into the ground. My coffee cup paused halfway to my lips as confusion settled over me. Nobody had mentioned anything about surveying at the last HOA meeting. My name is Marcus Chen, and I had owned this 4-acre property in the Whispering Pines community for nearly 15 years. When my wife Sarah and I bought this place back in 2011, we fell in love with the privacy, the mature trees, and the conservation easement that ran along the eastern boundary of all the properties in our subdivision. That easement was supposed to protect a creek corridor and ensure our neighborhood maintained its natural character. It was one of the main selling points when we signed the papers. I set down my coffee and walked across my lawn toward the survey crew. The evening air was cooling down and the cicadas were starting their nightly chorus. One of the surveyors, a younger guy with sun-bleached hair, looked up as I approached. "Evening," I called out. "Mind telling me what you are working on out here?" The young surveyor glanced at his companions before answering. "We are doing preliminary surveys for a new development project. Should be getting started in the next few months." My stomach dropped. "Development project? What are you talking about? This is protected land." The older surveyor, a weathered man with a clipboard, stepped forward. "According to our permits, the HOA sold the easement rights to Cascade Development Corporation 6 weeks ago. They are planning to put in a mixed-use facility, offices, and retail spaces. The access road will run right through here." He gestured along the tree line that bordered my property. I felt heat rising in my chest. "That is impossible. The easement is permanent. It was established when this subdivision was created. The HOA does not have the authority to sell it." The older man shrugged. "Take it up with your HOA, buddy. We just go where we are told. The paperwork all checked out with the county." I stood there for a moment, processing what I had just heard, before turning and walking back to my house with more speed than I intended. Sarah was in the kitchen preparing dinner when I burst through the door. "What is wrong?" she asked, immediately reading my expression. "The HOA sold the easement," I said, pulling out my phone. "They sold the conservation easement to some developer without telling anyone." Sarah's eyes widened. "They cannot do that, can they?" "That is what I am going to find out." I immediately called our HOA president, Linda Carpenter. Linda was a 52-year-old woman who had moved into Whispering Pines 3 years ago and had immediately inserted herself into every aspect of neighborhood governance. She had short blonde hair that she kept in a severe bob, always wore pressed pantsuits even to casual meetings, and had a voice that could cut through steel when she wanted to make a point. The phone rang 4 times before she answered. "Marcus, this is not a good time." "Linda, there are surveyors on the conservation easement. They said the HOA sold it to a developer. What is going on?" There was a pause. "We were going to announce it at next month's meeting. The board voted on it 6 weeks ago. It was a very lucrative offer, and the funds will go toward much-needed community improvements." "You cannot sell a conservation easement," I said, trying to keep my voice level. "That land was protected when the subdivision was established. It is in the original covenants." "Marcus, you need to understand that the HOA has the authority to make decisions in the best interest of the community. We had 3 lawyers review the sale. Everything is legal and proper. The developer, Cascade, offered us $2.3 million. That money will completely renovate our clubhouse, repave all the roads, and upgrade our pool facility. I want to see the documentation. The original covenants specifically protected that land." Linda's voice took on a sharp edge. "The original covenants have been amended multiple times over the years. The board has the authority to make these decisions. If you have concerns, you can bring them up at the next meeting. Now, I really have to go." She hung up before I could respond. Sarah looked at me with concern. What did she say? She said the board approved it 6 weeks ago, claims they had lawyers review everything. I ran my hand through my hair. But I know what was in those original covenants. I remember reading them specifically before we bought this place. Where are our closing documents? Sarah asked. That was when I remembered. When we bought the house, our real estate attorney, Bill Patterson, had given us a complete file with all the subdivision documents, including the original covenants and restrictions from when Whispering Pines was first established in 1997. I had kept everything in a fireproof safe in my home office. I went upstairs and pulled out the heavy folder. Inside were dozens of documents, but I found what I was looking for near the bottom. The original declaration of covenants, conditions, and restrictions for Whispering Pines subdivision, recorded with the Buncombe County Register of Deeds on March 15, 1997. I spread the document out on my desk and started reading. Sarah stood behind me, looking over my shoulder. It took about 20 minutes to find the relevant section, but there it was in black and white on page 14, Article 7, Section 3. A permanent conservation easement is hereby established along the eastern boundary of the subdivision, consisting of approximately 17 acres, to preserve the natural creek corridor and provide environmental protection. This easement shall run with the land in perpetuity, and may not be modified, amended, or terminated except by unanimous written consent of all property owners within the subdivision and approval by the North Carolina Wildlife Resources Commission. I read it twice to make sure I understood it correctly. Unanimous written consent of all property owners, I said aloud. There are 42 homes in this subdivision. Did they get everyone to agree to this? They never asked us, Sarah said, and I cannot imagine everyone agreeing to it. I took photos of the relevant pages with my phone, then called my neighbor Tom Rodriguez. Tom was a retired engineer who had lived in Whispering Pines for 20 years. If anyone knew about the history of the neighborhood, it was Tom. Marcus, good to hear from you, Tom answered. What can I do for you? Tom, did anyone from the HOA contact you about selling the conservation easement? Selling the what? His confusion was genuine. What are you talking about? I explained what I had learned from the surveyors and my conversation with Linda. Tom was silent for a moment. That woman, he finally said, his voice tight with anger. She has been running this HOA like her personal fiefdom since she got elected, but selling the easement, Marcus, that is protected land, that cannot be legal. That is what I thought. I just pulled out the original covenants. It says any change to the easement requires unanimous consent from all homeowners. Unanimous. They never asked me for anything. I would have said no immediately. Same here. Listen, can you spread the word? Call some of the other neighbors. I think we need to have an emergency meeting. I am on it, Tom said. This is not going to stand. Over the next 2 days, my phone did not stop ringing. It turned out that Linda and the HOA board, which consisted of Linda, her friend Patricia Walsh, and a guy named Jeff Morrison who barely participated in anything, had not informed the general membership about the easement sale. They had simply voted among themselves and moved forward with the transaction. By Thursday evening, I had confirmed that at least 35 of the 42 homeowners had never been contacted about the sale and would have opposed it if asked. Several people were livid. The conservation easement had been a major factor in their decision to buy in Whispering Pines. I spent Thursday night drafting a formal letter. In it, I outlined the violation of the original covenants, included copies of the relevant sections, and demanded that the HOA board immediately rescind the sale and notify the developer that the transaction was void. I sent copies via certified mail to Linda, Patricia, Jeff, and the HOA's management company. On Friday afternoon, I got a call from a number I did not recognize. When I answered, a smooth male voice greeted me. Mr. Chen, this is Richard Holloway. I am the attorney representing the Whispering Pines HOA. I understand you have some concerns about a recent transaction. That is putting it mildly, I said. The HOA sold property they had no legal right to sell. I can assure you that everything was done properly and legally. The board has the authority under the amended bylaws to make decisions regarding HOA assets. The conservation easement is not an HOA asset, I countered. It is a restriction that runs with the land, and the original covenants require unanimous homeowner consent to modify it. That consent was never obtained. There was a pause. Mr. Chen, I am not sure where you are getting your information, but the current governing documents give the board full authority. Those supersede any previous versions. The current governing documents cannot override a recorded covenant that specifically requires unanimous consent. That would be legally impossible without actually getting the unanimous consent first. Another pause, longer this time. I will need to review the documents you are referencing. Can you send me copies? I will do better than that. I am going to file them with the county and send copies to Cascade Development Corporation so they know they are buying into a lawsuit. Mr. Chen, I would strongly advise against taking any hasty action. Let's schedule a meeting to discuss this rationally. You can meet with me and the other homeowners who were not consulted about this. We will be calling an emergency HOA meeting. I will let you know when it is scheduled. I hung up and immediately called Tom. We need to organize an emergency meeting. Can you help me round up homeowners? Way ahead of you, Tom said. I have been talking to people all day. We can probably get 30 people together by tomorrow if you want to do something at the clubhouse. Let's do Sunday afternoon, 2 o'clock. That gives people time to adjust their schedules. I will spread the word. That evening, I received an email from Linda Carpenter. The subject line reads cease and desist, and my blood pressure rose before I even opened it. Mr. Chen, you are causing unnecessary panic and disruption in our community by spreading misinformation about the easement sale. The transaction was properly authorized and legally sound. Your interference is not only unwelcome but potentially actionable. If you continue to harass board members and spread false information, we will have no choice but to pursue legal remedies. This is your only warning. I showed the email to Sarah, who shook her head in disbelief. She is threatening you for telling the truth. She is panicking, I said. Which means she knows there is a problem. On Saturday morning, I drove to the Buncombe County Register of Deeds office in downtown Asheville. The building was an older structure with tall windows and marble floors that echoed with footsteps. I waited in line for about 15 minutes before a clerk could help me. I need to pull all recorded documents related to Whispering Pines subdivision, I told her. She typed into her computer. That is a pretty large subdivision. Are you looking for something specific? I need the original Declaration of Covenants from 1997, plus any amendments that have been recorded since then. Give me a few minutes. She disappeared into a back room and returned with a folder containing several documents. I paid the copying fee and sat down at one of the research tables to review everything. The original 1997 covenant was exactly as I remembered, but there were also 3 recorded amendments. The first, from 2003, dealt with architectural guidelines. The second, from 2008, updated the assessment structure. The third, from 2015, modified some rules about landscaping and fence heights. None of the amendments mention the conservation easement. More importantly, none of them included any language that would give the HOA board unilateral authority to modify or terminate the easement. The original language requiring unanimous consent was still in effect. I made copies of everything and also requested a copy of the deed for the easement sale to Cascade Development Corporation. The clerk found it, recorded just 8 weeks ago. The document showed that Linda Carpenter, as HOA president, had signed over the easement rights to Cascade for $2.3 million. But here was the problem. The deed made no mention of the unanimous consent requirement. It simply stated that the HOA, as the managing entity, was transferring the rights. Either Linda and her lawyers had not done their homework, or they had deliberately ignored the restrictions in the original covenants. I left the Register of Deeds office with a folder full of ammunition. Sunday afternoon arrived with perfect weather, sunny and 75 degrees. I got to the clubhouse at 1:30 to set up. The clubhouse was a modest single-story building with a meeting room, small kitchen, and bathrooms. It was not fancy, but it served its purpose. By 2 o'clock, 38 of the 42 homeowners had shown up. The only ones missing were Linda, Patricia, Jeff, and one elderly couple who were traveling. The meeting room was packed with people standing along the walls. Tom helped me set up a laptop connected to a projector so everyone could see the documents I wanted to show them. The mood in the room was tense but focused. I stood at the front and cleared my throat. Thank you all for coming on short notice. I know most of you have heard rumors about what is going on, so let me lay out the facts. I spent the next 20 minutes walking through everything. I showed them the original covenant language, explained the unanimous consent requirement, and displayed the recorded deed showing the sale to Cascade Development Corporation. I showed them that none of the recorded amendments had modified the easement provisions. The bottom line, I said, is that the HOA board sold something they had no legal authority to sell. They violated the governing documents and did not obtain the required consent from any of us. A woman named Jennifer Park, who lived on Maple Drive, raised her hand. What can we do about it? If the deed is already recorded, is it too late? No, I said. A deed that violates recorded covenants can be challenged and voided, but we need to act quickly. The developer has already started preliminary work. Tom stood up. I move that we vote to immediately demand the board rescind the sale and restore the easement. Second, called out at least 5 people simultaneously. The vote was unanimous among those present. I also think we need to consider removing the current board, Tom continued. They violated their fiduciary duty by making this sale without proper authorization. There was general agreement in the room, though a few people looked uncomfortable. A man named Steve Harrison spoke up. Should we at least hear from Linda and the others? Give them a chance to explain. I invited them, I said. I sent an email to all 3 board members about this meeting. They chose not to attend. At that moment, the door to the meeting room opened and Linda Carpenter walked in, followed by Patricia Walsh and a man I did not recognize, presumably a lawyer based on his suit and briefcase. This meeting is not authorized, Linda announced loudly. I am the HOA president and only I can call official meetings. Tom stood up. The bylaws allow any 10 homeowners to call an emergency meeting. We have 38 people here. This is completely legitimate. Linda's face flushed red. You are all being manipulated by Marcus Chen, who has a personal vendetta against this board. The easement sale was legal, proper, and in the best interests of this community. Then why didn't you tell anyone about it? Jennifer Park asked. Why did we have to find out from surveyors? We were planning to announce it at the next regular meeting, Patricia said. Her voice was defensive. There was no requirement to get advance approval for this type of transaction. I picked up my folder. Actually, there was. I projected the relevant section of the original covenant onto the screen. Article 7, Section 3. Any modification or termination of the conservation easement requires unanimous written consent of all property owners. You never obtained that consent. The lawyer stepped forward. I am Robert Dennison, counsel for the HOA board. The language you are citing is from an outdated version of the covenants. The current governing structure gives the board authority to manage HOA assets. The conservation easement is not an HOA asset, I repeated. It is a restriction on the land itself, recorded with the county, and nothing in any subsequent amendment modified the unanimous consent requirement. I have copies of every recorded amendment right here. Would you like to see them? Dennison's expression tightened. The board acted in good faith based on legal advice. Even if there was a procedural irregularity, the sale can be ratified by homeowner vote now. A vote now does not retroactively authorize a sale that already happened, I said. And ratification would still require unanimous consent according to the covenant. We already know at least 38 homeowners oppose the sale, so ratification is impossible. Linda's voice rose. You are destroying this community. That $2.3 million would have transformed our facilities. Instead, you want to keep a useless strip of trees that nobody even uses. That useless strip of trees is a creek corridor that provides wildlife habitat and prevents erosion, Tom shot back. It is also what makes this neighborhood attractive. Property values will tank if you put a commercial development right on our borders. We had it appraised, Linda shouted. The appraiser said the commercial development would increase property values. Let me guess, I said. The appraiser was hired by Cascade Development Corporation. Linda's face went even redder, which was answer enough. The meeting devolved into heated argument for the next 15 minutes. Finally, Tom called for order. We need to vote on removing the current board and installing an interim board to handle this situation. Dennison stood up. Any vote to remove board members requires 30 days' notice according to the bylaws. This meeting cannot take that action. I had anticipated this. You are right. But we can vote to direct the board to take specific actions, and if they refuse, we can hold a special election with proper notice. We took a vote. 38 homeowners voted to direct the board to immediately rescind the easement sale, notify Cascade Development Corporation that the transaction was void, and return any funds already received. The vote was unanimous among those present. Linda stood rigid, her face a mask of fury. This vote is meaningless. The sale is final. The funds have already been allocated. We are not going to undo a legal transaction because a mob got whipped up by false information. Then you leave us no choice, I said. We will pursue legal action to void the sale and remove the board. Good luck with that, Linda spat. You will spend hundreds of thousands in legal fees and lose. We have already prevailed in court. The judge approved the sale. This was new information. What judge? Judge Catherine Morrison in Buncombe County Superior Court. She reviewed the transaction and signed off on it as required for the transfer of conservation easements. I felt a chill. If a judge had already approved the sale, this was more complicated than I thought, but something did not add up. When did this hearing happen? 3 weeks ago, Dennison said. The court found that all legal requirements had been satisfied. Was there any opposition presented? Were homeowners notified of the hearing? Dennison shifted slightly. The HOA represented the interests of the homeowners. Individual notice was not required. There it was. They had gone to court without telling anyone, presenting only their side of the story. The judge had likely assumed the HOA board had proper authority and approved the sale based on incomplete information. We will be filing a motion to set aside that order, I said. Based on fraud or mistake, Linda laughed harshly. You do that. In the meantime, construction starts in 6 weeks. By the time you get anywhere with your little lawsuit, there will be concrete poured and buildings going up. Then we will see how much sympathy you get from a judge. She turned and walked out, Patricia and Dennison following her. The room was silent for a moment after they left. Then Jennifer Park spoke up. What do we do now? We hire a lawyer, I said. A good one, and we move fast. Tom nodded. I know someone, Rachel Kim. She is a land use attorney in Asheville. Handles HOA disputes and property rights cases. She is tough. Can you reach out to her? I asked. I will call her tonight. We spent another hour organizing. We established a legal defense fund and agreed that everyone would contribute equally. We also formed a committee to handle communications and coordinate efforts. I was elected to lead it, with Tom and Jennifer as co-chairs. By the time the meeting ended at 5:30, we had a plan. It was not going to be easy, but we had right on our side. That night, I could not sleep. I kept thinking about Linda's words. Construction in 6 weeks. If they started building before we could get a court order, it would be much harder to undo the damage. On Monday morning, Tom called me. I talked to Rachel Kim. She can meet with us tomorrow afternoon. Can you make it? Absolutely. Tuesday at 2 o'clock, Tom and I sat in Rachel Kim's office in downtown Asheville. She was a Korean-American woman in her early 40s, with sharp eyes and an efficient manner. Her office walls were lined with legal books and framed certificates. I walked her through everything, providing copies of all the documents. She listened carefully, taking notes, asking pointed questions. When I finished, she leaned back in her chair. "This is egregious," she said. "The HOA board violated the express terms of the recorded covenant. The unanimous consent requirement is crystal clear." "What about the judge's approval?" Tom asked. "That is a problem, but not an insurmountable one. If the HOA obtained the approval through misrepresentation or by failing to disclose the unanimous consent requirement, we can move to set it aside. The question is timing. We have 6 weeks before construction starts," I said. Rachel nodded. "Then we need to move immediately. I will file an emergency motion for a temporary restraining order and preliminary injunction. We will argue that the sale violated the recorded covenants and that irreparable harm will occur if construction proceeds. We will also move to set aside the prior court order based on the fraud on the court." "What are our chances?" I asked. "Honestly, pretty good. The law is clearly on your side. The only question is whether we can get a hearing scheduled quickly enough. Judges do not like to stop commercial projects without good reason, but this is not a close call legally. What do you need from us?" "I need affidavits from as many homeowners as possible stating that they never consented to the sale and that they oppose it. I need proof that the unanimous consent requirement was never satisfied, and I need a retainer to get started." We discussed fees. Rachel's rate was $350 per hour, and she estimated we would need at least $20,000 to get through the preliminary injunction phase. If it went to a full trial, costs could reach $60,000 or $70,000. Tom and I exchanged glances. It was a lot of money, but we had 38 homeowners willing to share the cost. "Let's do it," I said. Over the next 3 days, I collected affidavits from 36 homeowners. Each one stated that they had never been asked to consent to the easement sale, that they opposed the sale, and that they had relied on the conservation easement when purchasing their properties. 2 homeowners declined to sign, saying they did not want to get involved in the dispute. Rachel worked around the clock drafting the legal filings. On Friday afternoon, she submitted an emergency motion for a temporary restraining order to the Buncombe County Superior Court. She requested an immediate hearing. The court scheduled the hearing for the following Wednesday. That gave us 5 days to prepare. On Monday, I received a call from a blocked number. When I answered, a man with a gravelly voice spoke. "Mr. Chen, this is Frank Delgado. I am the president of Cascade Development Corporation. I understand there is some dispute about the easement we purchased." "That is correct," I said cautiously. "The HOA had no authority to sell it. Listen, I am a businessman. I do not want to get caught in the middle of a neighborhood fight. But I have $2.3 million invested in this project, plus planning costs and surveying expenses. I cannot just walk away. You bought something that was not legally for sale. That is not our problem. Maybe we can work something out. What if we modified the development plan, made it smaller, more in keeping with the neighborhood character? We could do residential instead of commercial." "The easement is supposed to be permanent conservation," I said. "No development." "Nothing is permanent, Mr. Chen. Everything is negotiable. What would it take to make this go away?" I felt anger rising. "It is not about money. It is about protecting the land that we were promised would stay protected." "Everything is about money," Delgado said. "Think about it. We could make it worth your while personally to help smooth this over with your neighbors. Are you trying to bribe me?" "I am trying to find a reasonable solution. You seem like a smart guy. Why waste time and money fighting when we could all walk away happy?" "I am not interested. See you in court." I hung up and immediately called Rachel to report the conversation. She was concerned. That could be construed as witness tampering or bribery, depending on how explicit he was. Did he name a specific amount? No, just implied that he could make it worth my while. Okay, keep a record of the call. If he contacts you again, do not engage. Let me know immediately. The days before the hearing passed in a blur of preparation. Rachel spent hours reviewing case law and crafting our arguments. I coordinated with the other homeowners, keeping everyone informed and collecting additional supporting documents. On Tuesday evening, the night before the hearing, I got another call. This time it was Linda Carpenter. "Marcus, we need to talk." Her voice was different, less aggressive. "I am listening." "This has gotten out of hand. Nobody wants a long, expensive legal battle. What if we compromised? We could agree to modify the sale, limit the development to the northern section of the easement, and keep the southern section as conservation." "Linda, you cannot partially sell something you had no authority to sell at all. This is not a negotiation. You violated the covenants and you need to make it right. You are being unreasonable. We are trying to improve the community. By selling protected land without authorization, that is not improvement, that is betrayal. You know what your problem is, Marcus. You think you are smarter than everyone else. You think you know better than the elected board. Well, we will see what the judge says tomorrow." She hung up. Wednesday morning arrived with gray skies and a threat of rain. I put on my best suit and met Tom, Rachel, and Jennifer Park at the courthouse at 8:30. The hearing was scheduled for 9. The courtroom was an impressive space with high ceilings, dark wood paneling, and rows of benches. Judge Catherine Morrison presided, a woman in her early 60s with silver hair and a no-nonsense demeanor. Linda, Patricia, and Jeff sat on the other side of the courtroom with their attorney Robert Dennison, and another lawyer I did not recognize. Frank Delgado from Cascade Development was also there with his own legal team. Judge Morrison called the case at 9:15. Rachel stood and presented our motion for a temporary restraining order and preliminary injunction. "Your Honor, this is a straightforward case of a homeowners association violating the express terms of recorded covenants. The original Declaration of Covenants for Whispering Pines subdivision, recorded in 1997, established a permanent conservation easement with specific language requiring unanimous written consent from all property owners before any modification or termination. That consent was never obtained. In fact, the vast majority of homeowners were not even informed of the proposed sale until after it was completed. She handed up copies of the original covenant and the affidavits from 36 homeowners. The HOA board claims they had authority under amended bylaws, but no recorded amendment has modified the unanimous consent requirement. They also obtained an order from this court approving the sale, but they did so without disclosing the unanimous consent requirement and without providing notice to the affected homeowners. That order should be set aside as procured by fraud or mistake. Judge Morrison reviewed the documents. Mr. Dennison, I presided over the prior hearing approving this sale. I do not recall seeing anything about a unanimous consent requirement. Dennison stood. Your Honor, the unanimous consent language is from the original 1997 covenant, which has been superseded by subsequent amendments and bylaws. The current governing documents give the board full authority to manage HOA assets and make decisions in the best interest of the community. The conservation easement, while originally established as a restriction, became an HOA asset over time through the evolution of the governing structure. That is creative legal reasoning, Judge Morrison said dryly, but it does not change what was recorded. The 1997 covenant is still the operative document regarding the easement unless it was properly amended. Do you have any recorded amendments that specifically modified the unanimous consent requirement? No, Your Honor, but the holistic interpretation of all the governing documents together shows the intent to give the board broad authority. Mr. Dennison, I am a judge, not a mind reader. I look at what is written and recorded. If the 1997 covenant says unanimous consent is required, and no recorded amendment changed that, then unanimous consent is still required. Did the board obtain unanimous consent from all 42 homeowners? No, Your Honor, but we contend that requirement is no longer valid. Based on what legal authority? Dennison scrambled through his notes. Based on the implied authority of the board under the evolved governance structure. Judge Morrison turned to the Cascade Development attorney. Counselor, did your client conduct due diligence before purchasing this easement? The Cascade attorney, a tall man with wire-rimmed glasses, stood. Yes, Your Honor. We reviewed the current HOA bylaws and the deed history. The title search showed the HOA as the holder of the easement rights. Did you review the original subdivision covenants? We reviewed the current governing documents that were provided by the HOA and their counsel. So you did not look at the recorded covenants from 1997, the attorney hesitated. Not specifically, Your Honor. We relied on representations from the HOA and their attorney that they had authority to sell. Judge Morrison set down the documents and looked at Dennison. Counsel, I am very troubled by this situation. When you came before me 3 weeks ago seeking approval for this sale, you did not disclose the unanimous consent requirement from the 1997 covenant. You represented that the board had authority to proceed. That representation now appears to have been false or at minimum misleading. Your Honor, we believed in good faith that the board had authority. Good faith requires actually checking the recorded documents, Mr. Dennison. Did you review the 1997 covenant before filing the motion for approval? Dennison's face reddened. I reviewed the documents provided to me by the board. That is not what I asked. Did you personally review the recorded 1997 covenant? No, Your Honor. Then how could you represent to this court that all legal requirements were satisfied? The courtroom was silent. Judge Morrison turned back to Rachel. Miss Kim, I am prepared to grant your motion for a temporary restraining order. I am also going to set aside my prior order approving the sale as it was procured based on incomplete information. I am scheduling a full hearing on the preliminary injunction for 2 weeks from today. In the meantime, Cascade Development Corporation is prohibited from beginning any construction or site work related to this property. The status quo is preserved until we can fully litigate this issue. Relief flooded through me. Tom gripped my shoulder, but Dennison was not finished. Your Honor, with respect, setting aside your prior order is highly irregular. We request that you allow us time to submit additional briefing on the legal issues. You will have that opportunity at the preliminary injunction hearing, Mr. Dennison. But based on what I have seen today, it appears this sale violated recorded covenants and was pushed through without proper authority. I am not going to allow construction to proceed while that is being litigated. The temporary restraining order is granted. We are adjourned. Judge Morrison stood and left the courtroom. I let out a breath I had not realized I was holding. Rachel turned to us with a small smile. That went well. She saw right through their arguments. Across the courtroom, Linda Carpenter looked like she wanted to throw something. She was in heated conversation with Dennison and the Cascade attorneys. Frank Delgado looked furious. As we walked out of the courthouse, Delgado intercepted us in the hallway. You just cost me a lot of money, he said, pointing at me. You cost yourself money by not doing proper due diligence, I replied. This is not over. I will sue the HOA for fraud. I will sue you personally for interference. Go ahead, Rachel said calmly. We will see you in court. Delgado stalked off, his lawyers hurrying after him. Outside the courthouse, rain had started to fall. Tom, Jennifer, and I stood under the overhang watching the rain. We did it, Jennifer said. We actually stopped them. For now, I cautioned, we still have the full hearing in 2 weeks. But this is a good start. Over the next 2 weeks, things moved quickly. Frank Delgado made good on his threat and filed a lawsuit against the HOA board, seeking return of his $2.3 million plus damages for fraud and breach of contract. That lawsuit complicated things, but it also put pressure on Linda and the board. Rachel continued building our case. She deposed Linda, Patricia, and Jeff, as well as Robert Dennison. The depositions revealed that Linda had been the driving force behind the sale. She had been approached by Cascade Development about a year earlier and had negotiated the deal largely on her own. Patricia and Jeff had gone along with minimal involvement or oversight. More troubling, the depositions revealed that Dennison had warned Linda about potential issues with the original covenants, but that Linda had assured him the board had authority to proceed. Dennison had relied on that assurance without doing his own independent review. It was legal malpractice, plain and simple. The depositions also revealed where the $2.3 million had gone. Linda had already spent $400,000 on architectural plans for a new clubhouse and had signed contracts for another $800,000 in renovations. The rest was in an HOA account, but there were legal complications about returning it since Cascade was now suing for its return. Meanwhile, I started getting anonymous harassing calls and emails. Someone created a fake social media account claiming I was a troublemaker trying to prevent community improvements. Someone else posted my home address online with suggestions that people should let Marcus know what they think of him. Sarah was scared. This is getting out of hand. Maybe we should just drop it. We cannot, I said. If we let them get away with this, it sets a precedent that the HOA can violate any rules they want, and the harassment proves they know they are in the wrong. I reported the harassment to the police, who said they would investigate but could not do much about anonymous online posts. The preliminary injunction hearing arrived on a cloudy Thursday morning. This time, the courtroom was packed. At least 20 homeowners from Whispering Pines showed up to watch. Local media was there too, after a newspaper reporter caught wind of the story. The hearing lasted most of the day. Rachel presented a thorough case, walking through the covenant language, the lack of unanimous consent, and the HOA board's violation of their fiduciary duties. She called me as a witness to testify about never being asked for consent and about discovering the surveyors on the property. Dennison tried to argue that the covenant language was ambiguous and that unanimous consent could be interpreted as consent from the board acting on behalf of the homeowners. Judge Morrison was not buying it. Counsel, if the drafters of the covenant wanted board approval, they would have said board approval. They said unanimous consent of all property owners. That is not ambiguous. Dennison also tried to argue that enforcing the covenant would create an economic hardship for the HOA, which now faced a lawsuit from Cascade Development. That hardship is self-created, Judge Morrison responded. The board chose to proceed with a sale without obtaining required consents. They must deal with the consequences. At the end of the day, Judge Morrison issued her ruling from the bench. I am granting the preliminary injunction. The sale of the conservation easement violated the recorded covenants and is void. The easement remains in place, and Cascade Development Corporation is permanently enjoined from proceeding with any development on that land. As for the financial issues between Cascade and the HOA, that will be resolved in their separate lawsuit, but this court's role is to enforce the recorded covenants which clearly prohibited what occurred here. She paused, then continued. I am also referring this matter to the North Carolina State Bar for investigation of Mr. Dennison's conduct. An attorney has a duty to conduct adequate due diligence before making representations to the court. That duty was not fulfilled here. Dennison's face went pale. Finally, Judge Morrison said, I am ordering the HOA board to notify all homeowners of this ruling and to hold a special election within 60 days to allow the membership to decide whether the current board should remain in place. The board's actions in this matter demonstrate a troubling disregard for the governing documents and the rights of the homeowners they represent. The courtroom erupted in applause from the Whispering Pines homeowners. Judge Morrison gavelled for order but looked satisfied. As we left the courtroom, a reporter approached me. "Mr. Chen, can I get a statement?" I glanced at Rachel, who nodded. "Our community has preserved land that was promised to be protected forever," I said. "This is a victory for everyone who believes that rules and covenants matter, and that elected leaders must follow the law." The story ran in the Asheville Citizen-Times the next day with the headline, "HOA illegally sold conservation land, judge rules." It included quotes from me from Linda, who claimed they had acted in good faith and were disappointed by the ruling, and from Frank Delgado, who said he was proceeding with his lawsuit against the HOA. The atmosphere in Whispering Pines over the next few weeks was tense. Linda and Patricia resigned from the board rather than face a recall election. Jeff Morrison, who had mostly been a passive participant, stayed on but announced he would not seek re-election. The special election was held 6 weeks later. Tom Rodriguez was elected as the new HOA president. Jennifer Park and I were elected to the board as well. Our first order of business was to settle the lawsuit with Cascade Development. Cascade wanted their $2.3 million back, plus damages. We negotiated a settlement where they received the full purchase price refund, but waived any damage claims. The HOA's insurance covered most of the refund, though we had to assess each homeowner an additional $2,000 to cover the gap. It was expensive, but it was worth it to resolve everything. We also had to deal with the $400,000 that Linda had spent on architectural plans and the $800,000 in renovation contracts she had signed. We canceled what contracts we could and ate the losses on the rest. It was a painful financial hit, but we restructured the HOA finances to cover it over several years. The fallout continued. Frank Delgado was angry about losing the development opportunity and started making public statements claiming the neighborhood had acted in bad faith. He threatened to sue individual homeowners, but nothing ever came of it. His lawyers probably told him he had no case. Robert Dennison faced a state bar investigation. I do not know all the details, but I heard through the grapevine that he received a formal reprimand and had to complete additional continuing education on professional responsibility. His reputation took a hit, and several of his HOA clients dropped him. Linda Carpenter moved out of Whispering Pines about 6 months later. I heard she relocated to Charlotte and kept a low profile. Patricia Walsh stayed but was no longer involved in community affairs. The two homeowners who had supported the sale, the ones who had not signed the affidavits, kept quiet and avoided neighborhood events. As for me, serving on the HOA board was more work than I expected, but it was important. We implemented new policies requiring transparency and homeowner approval for any major transactions. We also updated the bylaws to make it crystal clear that the conservation easement was off-limits. The most satisfying moment came about a year after the whole ordeal ended. I was walking along the trail that ran through the conservation easement with Sarah. It was a beautiful spring afternoon, and the creek was running high from recent rains. We saw a family of deer grazing in the meadow, and a great blue heron was fishing in the shallows. "I am glad we fought for this," Sarah said, taking my hand. "Me too." We stood there for a while, watching the heron, listening to the water, feeling the peace that comes from knowing you did the right thing. The developers and their bulldozers never came. The trees remained standing. The creek kept flowing, and Whispering Pines stayed the quiet, natural community we had fallen in love with 15 years earlier. There was one final piece of business. About 18 months after Judge Morrison's ruling, I received a letter from the North Carolina Wildlife Resources Commission. They had been notified about the attempted sale of the easement and had opened their own investigation. The letter informed me that the commission was taking additional steps to protect the easement. They were filing their own declaration with the county, documenting their interest in the conservation values of the land and their authority under state law to enforce the easement protections. This would provide an extra layer of security to prevent any future attempts to develop or sell the land. I framed that letter and hung it in my office, right next to the original covenant document. The whole experience taught me several important lessons. First, that the rules and covenants we agree to when buying property matter, and they should be enforced. Second, that HOA boards have power, but that power is not unlimited. They are bound by the same governing documents as everyone else. Third, that standing up for what is right is not always easy or convenient, but it is necessary. I also learned that most people want to do the right thing when they understand what is at stake. The 38 homeowners who stood with us against the easement sale were not activists or troublemakers. They were regular people who cared about their community and their property values. When they understood that the HOA board had violated the rules and threatened the character of the neighborhood, they stepped up. There are still HOA boards out there that act like mini dictatorships, thinking they can do whatever they want without accountability. Linda Carpenter was not unique in that regard. But there are also homeowners like me, like Tom, like Jennifer, who are willing to dig through dusty old documents, hire lawyers, and stand up in court to protect what is right. The conservation easement along Whispering Pines remains intact today. Kids play in the creek, birds nest in the trees, deer browse in the meadow. And on quiet evenings, I still sit on my back porch with my coffee, watching the sunset paint the Blue Ridge Mountains in shades of orange and purple, grateful that we preserved this little piece of nature for future generations. Sometimes I think about what would have happened if I had not noticed those surveyors that evening. What if I had been traveling for work or had simply ignored them? The easement would have been sold, the developer would have started construction, and by the time anyone realized what happened, it would have been too late to stop it. That thought makes me check the county property records every few months, just to make sure nothing else has been filed without our knowledge. Call it paranoia if you want, but I call it being vigilant, because the price of preserving what matters is constant attention. Tom jokes that I am the neighborhood watchdog now. He is probably right, but someone needs to pay attention, to ask questions, to read the fine print. Someone needs to remember that the covenants and restrictions we all agreed to are not just suggestions. They are legally binding obligations that protect all of us. The Cascade Development Corporation eventually built their mixed-use facility somewhere else, about 15 miles south of Asheville. I drive past it sometimes. It is a typical modern development, all glass and steel and parking lots. It is fine for what it is, but I cannot imagine it sitting where our conservation easement is. The thought of bulldozers tearing through those trees of concrete covering the creek banks still makes my stomach turn. Linda Carpenter never apologized. I heard through mutual acquaintances that she still believes she was right, and that the neighborhood made a mistake rejecting the development. She thinks we cost ourselves millions in property value increases and facility improvements. She does not understand that some things are more valuable than money, or maybe she understands perfectly well and just does not care. Some people view everything as a transaction, every piece of land as something to be bought and sold and developed. They cannot comprehend why anyone would want to preserve open space or wildlife habitat when there is profit to be made. I do not have any animosity toward Linda anymore. In some ways, I am grateful to her. If she had not tried to sell the easement, I never would have dug out those old covenant documents. I never would have learned just how important it is to preserve and protect what we have. I never would have gotten involved in HOA governance or met all the wonderful neighbors who stood up with us. Sarah says the whole experience changed me. She says I am more engaged now, more willing to speak up when something does not seem right. She is probably correct about that too. Before all this happened, I was content to let others handle neighborhood business. I paid my dues, followed the rules, and stayed out of HOA politics, not anymore. Now I read every meeting notice, every financial report, every proposed rule change. I ask questions. I verify information. I make sure our board is following the governing documents and acting in the best interests of all homeowners, not just a select few. Some people find this annoying. At a recent HOA meeting, someone asked if I was ever going to stop being so suspicious of everything. I told them that vigilance is not suspicion. It is just being responsible. The conservation easement case became something of a legend in Asheville legal circles. Rachel Kim told me she has had several other HOA clients come to her with similar issues after reading about our case. Apparently, HOA boards overstepping their authority and ignoring governing documents is more common than I realized. Rachel has won several cases now, enforcing covenants and restrictions against boards that thought they could do whatever they wanted. She says we set an important precedent, showing that homeowners can successfully challenge illegal board actions if they are willing to stand up and fight. I also heard that the North Carolina legislature considered passing new laws to increase HOA transparency and accountability after our case received media attention. I do not know if anything came of that, but I like to think we made a difference beyond just our own neighborhood. My kids, who were teenagers when all this happened, learned some important lessons from watching the whole ordeal unfold. My daughter Emily, who is now in college studying environmental science, says the case inspired her interest in conservation law. My son James says it taught him that standing up for what you believe in matters, even when it is difficult. I hope they are right. I hope they take those lessons forward into their own lives and communities. Because places like Whispering Pines exist all over the country, and there are Linda Carpenters everywhere, people who think rules do not apply to them and who are willing to sacrifice community values for personal gain or misguided improvements. The creek that runs through our conservation easement eventually flows into the French Broad River, which winds through Asheville and eventually joins the Tennessee River. It is part of a larger ecosystem, connected to everything around it. In the same way, our neighborhood is part of a larger community, connected to the wider world. What happens in Whispering Pines matters, not just to the 42 families who live here, but to everyone who values the rule of law, property rights, and environmental conservation. Every time someone successfully stands up against corruption or overreach, it makes it a little easier for the next person to do the same. I still have the original covenant document in my safe, along with all the other documents from the case. Sometimes I take them out and read through them, reminded of how close we came to losing something irreplaceable. The language is formal and legal, but its meaning is simple. This land is protected forever, and that protection cannot be undone without everyone agreeing. Forever is a long time. Longer than any HOA board's term. Longer than any development boom, longer than the profit motive or the desire for fancy new facilities. Forever means we are protecting this land not just for ourselves, but for people who have not even been born yet. That is what Linda Carpenter never understood. She was thinking in terms of her tenure as HOA president, maybe 3 or 5 years. She wanted accomplishments she could point to, visible improvements she could take credit for. She never stopped to consider that some things are meant to last beyond our individual lives. The original developers who created Whispering Pines back in 1997 understood this. They set aside that conservation easement knowing full well it would reduce the total number of homes they could build, which meant less profit for them. But they did it anyway because they wanted to create a community that would endure, that would maintain its character and natural beauty for generations. We were the guardians of their vision. When Linda tried to sell the easement, we had a choice. Let it happen and lose what made our neighborhood special, or fight to preserve what we had been entrusted with. We chose to fight, and I am grateful we did. The irony is that property values in Whispering Pines have increased significantly since we stopped the development. People want to live here specifically because of the protected open space and natural character. The conservation easement is a selling point, not a liability. Several homes have sold in the past year at prices well above what Linda's appraiser predicted they would be worth with the commercial development. So even from a purely financial standpoint, enforcing the covenant was the right decision. But I would like to think we would have made the same choice even if property values had decreased. Some things are more important than money. As I write this, I am sitting on my back porch again, watching another sunset paint the mountains. It is early autumn now and the leaves are just starting to turn. The air has that crisp quality that comes with the changing seasons. Somewhere in the conservation easement, a barred owl is calling, its distinctive "who cooks for you" echoing through the trees. This is what we fought for. This peace, this beauty, this connection to the natural world that is becoming increasingly rare in our modern, developed landscape. Every evening when I sit here, I am reminded that the fight was worth it. I do not know what the future holds for Whispering Pines. New homeowners will move in, bringing their own ideas and priorities. Board members will come and go. There will be other disputes and other challenges. But the conservation easement will remain, protected by the covenant we enforced and by the precedent we established. And if someday, years from now, another HOA board gets ambitious ideas about selling or developing the protected land, there will be documents in the county records to stop them. There will be my affidavit and the affidavits of 36 other homeowners. There will be Judge Morrison's ruling. There will be the North Carolina Wildlife Resources Commission's declaration. Most importantly, there will be the knowledge that homeowners can successfully stand up to an overreaching board. That precedent alone makes everything we went through worthwhile. Sarah comes out onto the porch with 2 glasses of wine. She hands me one and settles into the chair beside me. "What are you thinking about?" she asks. "Just remembering," I say. "Thinking about how different things could have been." She nods, understanding without me having to explain. We sit in comfortable silence, watching the last light fade from the sky, listening to the sounds of the evening. Tomorrow, I have an HOA board meeting. We will discuss routine matters like landscaping maintenance and pool schedules. It will be boring and bureaucratic, the kind of thing that makes most people's eyes glaze over. But I will pay attention to every detail, read every report, ask every question, because that is what it takes to protect a community. Not grand gestures or dramatic courtroom battles, though those have their place. Mostly it takes showing up, paying attention, and being willing to speak up when something is not right. Linda Carpenter taught me that lesson, though I doubt she intended to. She showed me what happens when leaders forget they are servants of the community, not its masters. She showed me the importance of reading the fine print, understanding the rules, and holding people accountable. In the end, the story of the Whispering Pines conservation easement is not really about an HOA board's illegal sale or a legal battle or even a courtroom victory. It is about a community coming together to protect what matters. It is about ordinary people doing extraordinary things when the situation demands it. It is about a man noticing surveyors on his property line and having the curiosity to ask questions. It is about neighbors signing affidavits and contributing to a legal defense fund. It is about a lawyer working tirelessly to present the truth to a judge. It is about that judge having the wisdom and courage to make the right decision. Most of all, it is about remembering that we are temporary stewards of the land we own. We do not truly possess it, we hold it in trust for those who come after us. The decisions we make today will echo far into the future. As darkness settles over the mountains and stars begin to appear in the sky, I raise my glass in a silent toast. To the conservation easement. To the neighbors who stood with us. To Rachel Kim and Judge Morrison. To everyone who believes that some things are worth fighting for. The owl calls again from the woods and I smile. The trees remain standing. The creek keeps flowing. And Whispering Pines endures, protected and preserved, exactly as it was meant to be.